Adrian's question relates to the Consumer Protection Act, mostly around the liability for damage caused by goods. So here I'm thinking about, certain damages in a property that actually cause subsequent damages, be it to the person or to other assets on the property, whatever, things falling from the ceiling, that sort of thing, right? That aren't supposed to be there. So a liability, but his primary focus is around the timeframes in which one, presumably the seller, could actually be held liable, or the agents. So the seller or the agents, where it can be proven. So we're not doing that connection now, but the sellers or the agents, how long will they be liable for damages, like period of time wise? And now this is a question in terms of the Consumer Protection Act, but I'm probably going to suggest Nick also just mention our normal prescription laws. Yeah, so it's a question of, can a person actually wait just before the end of the 3 years and institute the claim? Is that allowed? Is there a claim that can be made after the 3 years, just because I found out about the defect? And like you and I discussed, there's different angles to that. And yeah, I think that's the question in a nutshell.
Yeah, so I think this one's going to be more of a discussion between the two of us, because there are a lot of aspects, and there's a lot of discussion about this, and where what damage. Again, one of those that depends on facts. But let's start with prescription. So this might be a concept that's not familiar to a lot of our listeners, and it's an important one that you should have in your mind. In South African law, we have the Prescription Act. Basically, what the Prescription Act does is it places a limitation on your ability to claim damages against certain other parties within law based on time. Okay. Now, there is a tiered system that's set out within the Prescription Act for different types of parties, and how long you have to claim against those particular parties. Okay. But the one that is most important for ordinary citizens, from citizen to citizen, so you and your neighbor, is a period of 3 years. Okay. So if you suffer damages, what the law expects of you is to raise that claim for damages against whoever caused you that damage within a period of 3 years. If you wait longer than that period of 3 years, your claim has become what's called prescribed. So it's no longer legally enforceable in law. So you can approach a court, but what the other party can do is basically say, no, I'm no longer liable for that damage because the claim has become prescribed, and the court will then make an order that they're not liable because of the prescription. So this is important to realize. The act is not only 3 years. There are certain indulgences that are given to certain entities within our law. For instance, if you think you're going to get away from paying your rates and taxes because the government hasn't chased you in a period of 3 years, you're not going to get away with it. They have a massive indulgence on how long.
And SARS.
SARS, agreed. So there's certain entities who have a much longer period, and you hope they don't take a long time. But this is why SARS can backdate your taxes for years and years and years, and then they come after you. So the basic idea is 3 years. Okay. Now, that is 3 years from the time that you've got knowledge of the damage that has occurred to you. Okay. And what's interesting is the Consumer Protection Act, basically in the section that our listener is talking about, basically tries to mimic that. So it says that in the section that's quoted, it's section 61.4, basically says that you won't be liable unless or if you bring a claim more than 3 years after you've become aware of the damage which you've incurred. Okay. And our listener basically posits the situation where, say, I haven't been made aware of the damage for a period of 10 years. Do I have now 13? Okay, being 3 years after I've become aware of the damage, to institute my claim. Okay, so the first thing is with regard to prescription in general, and it will apply in this act as well. That 3 year period, you are perfectly entitled to wait until the day before 3 years after you've incurred your damage to institute your proceedings, and it's not an uncommon thing in law. In fact, lawyers will often engage with someone who caused damage, or or attorneys to try and sort out a problem before prescription occurs. And then they will try interrupt prescription, and you have to interrupt prescription by actually approaching a court and instituting a claim. And this is an acknowledgement of the damage that has occurred. Okay, but it's very common for attorneys to try and sort out problems before approaching a court, and then institute the proceedings just before the end to make sure that prescription doesn't occur. And in fact, attorneys have a duty to make sure that claims don't prescribe on their watch. It's a very important duty that we have. If we have a case, we make sure that things don't prescribe and our clients don't lose their claim. With that, though, there is a certain duty on behalf of the person who's going to claim damages. So the idea that 10 years, you can wait 10 years, find out about a damage, and then institute your claim for prescription, while it may be possible, depending on the circumstances of a particular case, you're going to have a hard time. Okay, you have a duty to make, to obviously look after your things and find out, what is wrong with them. So if you are in a situation where you turned a blind eye to some damage which has occurred, okay, and you've got the phrasing is sort of a reasonable person. They're going to look at a reasonable person in circumstances and what they would have noticed. If you turn a blind eye to something that's clearly damaged, for a period of 10 years, and then decide to institute your proceedings thereafter, or you just don't want to institute it and only do it in year 5, but you clearly knew that the damage was there, the court's not going to look favorably on an argument that, well, I didn't know about the damage. The court again is going to say, but a reasonable person would have known that damage was there, and so you should have acted, timeously in accordance with your knowledge of that particular damage. And I think one of the other things, bringing this back to property and transfers of immovable property from a seller to a purchaser, is there are a couple of other factors at play when you have a sale like this. Obviously, in terms of a sale agreement, you're going to have a footsteps clause. And I know we've talked about how footsteps clauses interplay with the mandatory disclosure form and how enforceable they are now. And obviously, there's still some questions around that. But once a property transfers, risk and possession of that property is going to transfer in terms of the agreement. Generally, that's on registration of transfer. It can be amended in terms of a deed of sale to, for instance, give risk and possession upon occupation if a purchaser is going to pay occupational rent. And so from that point, really, you need to be looking at what, if there are any particular damages which you've suffered at that point, because anything from beyond that point, in my view, is going to fall on your lap. So you can't sit around and expect that every time you have a problem on a property which you've purchased, 5-10 years prior, is actually the problem of the seller. At that point, when risk and possession passes, that's now your property. You've got to now look after it, and any defects that arise, that's your responsibility.
So totally agree with you. And as you were speaking, I was trying to think of different examples to mention, and it occurred to me it's so difficult, especially when it comes to goods, when it comes to damage, like defects, footsteps, that sort of thing. Because the reason the 3-year period exists, obviously, is because after a certain point in time, it becomes very difficult to prove certain facts. And it almost becomes unfair to expect a person who you have a claim against to have records, have recollection, be able to call witnesses, that sort of thing. So the 3-year rule is for reasonableness. Obviously, government and SARS get the upside to it because they want to be able to make sure that no matter what, SARS is allowed to audit you even 10 years down the line. Even though if you only need to keep the info for 5 years, they can still come after you if they have certain grounds to believe that you haven't paid all your taxes in a fraudulent way. And so ignoring that for a second and looking at the purpose of the 3-year thing, it is about fairness. If you know you have a claim, do it. If not, you're going to lose your right to. So it's really the ball's in your court. So now when we look at the Consumer Protection Act, it re-emphasizes that by saying, look, we give you all these protections. We speak about defects, footstoots to a certain extent. You know, you can ignore if A, B, and C. You know, there's defects that you know, people were aware of, or any defect that you find within a certain period of time, and any damages resulting from that defect. Problem now is you need to remember practically what happens. If you buy something, especially a property, number one, it's very difficult for you 10 years down the line to say, oh, you know what, that the roof trusses were actually not in a good condition. I didn't know this 10 years back, but now I know this, and it was definitely from when I bought it for you. Because unless you're able to prove without a doubt that this was something that was hidden, that there was no responsibility on you at all to realize that this was the case, and proving that the damage only actually occurred, or rather didn't only occur after you had bought the property, it's virtually impossible. And no one's going to entertain that and say that, I mean, even if they entertain a case, you're going to have an uphill battle trying to prove that the defect was on the seller side. So you as a consumer have very little protection. So if we start looking at timeframes, they exist for a reason. Yes, hypothetically speaking, if you had the perfect claim that you had no way of ever knowing, and the damage can be proven to have been there by the, you know, at the point that the seller sold the property, and you only really found out about it at a certain point 10 years down the line, hypothetically, right? If you could prove all of those points and the seller could not disprove, or rather couldn't prove otherwise, potentially, yes, there's a claim. But there you're dealing in like 1 in a million, because I've never experienced something 10 years down the line that is that bad. Yes, arguably, maybe with developments and things like that, people have had arguments over badly built buildings. But a lot of the times before 10 years, you start noticing that something is wrong. So even if the 3-year mark has lapsed from the date of the transaction, yes, you might be able to say, well, I only found out about it now. 10 years is a bit of a stretch on this point. So to answer your question, yes, it is possible. Yes, there have been cases where even after a certain period of time, the clock can start running because you only found out about it. But the longer the time goes, the harder it is. And that's a fact.
Yeah, no, absolutely. Couldn't agree more.
Cool. I think, does that answer the question in full? I think so.
I believe it did.
Yeah, cool. Awesome. Then, Nick, thank you. Always a pleasure.
Same here.
Cool. And then I'll probably see you next week.
Yes, probably will. All right, Bruno, have a good one.
Cheers. You too.
Yes.